No one really knows like what's coming and what are the consequences of using AI. A big part of it is consumer protection, especially in the Digital Services Act. People, they don't know if AI is used. Am I writing to a chatbot or to a real person? A lot of it is for the security of natural people. If they are not aware of that, they get the information that AI is used or that AI may be in the background. That's a real issue why the European Union is doing all this. From the data protection point of view, it's not really getting any easier for companies, startups, whatever.
Hello and welcome to Let's Talk About Tech. It's my great pleasure to introduce you today to an attorney-in-law for marketing IP specialized on startups, Jacqueline Bichler. Great to have you, Jacqueline.
Hi, great to be here.
It's amazing to see that there's more and more lawyers specialized on our sector, on the tech sector, e-commerce, startups, and there's many topics we can touch. But as usual, we start with your background story. You grew up in Vienna. You went to an elite school, the Theresianum, where a lot of those alumni end up being lawyers. Was it the school that drove you and inspired you for this job?
Not really. I mean, I have to say my parents are lawyers, so I'm the first lawyer in the family. It might have been a school a little bit, but I was always interested in the law stuff a little bit. So yeah, I decided to go to law school, and I think it was the right decision.
Originally, you thought about becoming a judge, right? And here the government just decided to not have jobs available?
Yeah, it was this year where we all like were ended by the government, and then I traveled a bit, and I just decided, well, what are my other options? And then I saw the posting from STADLER VÖLKEL, and it really attracted me, so I decided to go for it, and yeah, that's how it went.
And STADLER VÖLKEL is well known as a startup law firm specialized also in Web3, so in the very modern stage, next generation of the internet. Here, everything around tokens. Now, you did not decide for the token world, you did not decide for M&A, you did not decide for commercial law, right? You decided to become a specialist for IP, marketing, e-commerce. Why this field and why not the others?
I think it was like more interesting. The people I work with are more cooler, more relaxed, and I think it's not the very strict lawyer business. And I was interested in IP law, competition law in university, and I thought it's more a creative area where I can be more creative and be more relaxed with the clients. And it just felt right, so I decided to go this way.
Okay. I'm not sure if litigation on marketing matters is that relaxing, but it's definitely different to a transaction, I would assume.
Yeah, it depends. I mean, of course, we have litigation regarding copyright issues or trademark issues, but I like that as well. So I'm not afraid to do it, as well as criminal court hearings. I love that. But I'm happy when all the other stuff and projects are handled in a law firm and not going to court every day, to be honest.
Right. So we're not sitting here to hire you to go to court for us, right? Because we don't want to do something wrong, right? And we also don't want to get sued by someone. So basically, we try to keep you out of this part of the business, but we want to learn from you, what are the pitfalls for startups? What are the laws on a European level, right? And I think in marketing IP law, there's a lot of European regulations, European directives that have an influx for a startup and a growth business. What are the typical laws that startups have to keep in mind when they start selling goods online or digital products? Tell us a little bit about that.
I mean, as you said, there are many regulations and directives. For example, if I want to implement a web shop and sell product, of course, there's the directive on consumer rights, which is implemented in our e-commerce act. And there is stuff like right of withdrawal, the correct checkout process and everything, how to present my products, issues about the pricing and everything. So consumer rights is always an issue. Then the directive against unfair commercial practices, which is important when it comes to marketing, influencer marketing, how to advertise, and also how to set up the prices for my products. And the Federal Act Against Unfair Competition in Austria is like all issues which are relevant for startups are almost in this law. So I think those are the two most important directives. And as well, like the topic everyone's concerned about still, the GDPR. I mean, it's in force like since 6 years, and it's still important as in the beginning. And of course, issues like Digital Services Act or AI Act, which might be more important in the future. And Digital Services Act, especially when it comes to marketing for younger generations, profiling, and such topics. So I think those are the most important laws, regulations, which might be interesting for startups.
Let's dive a little bit deeper. So, if I'm a startup founder and I come to your law firm and I say I'm thinking about building my e-commerce business, do you have something like a legal boot camp for them to train them to get them up to speed of what's the current regulation, and how do you keep your clients up to date on the latest regulations or what's to come? Because there's always new things,
Yeah,
right?
of
And
course.
you have to adapt all the time.
Yeah, of course. I mean, of course, we have the issues which have to be done beforehand, especially before going online. That's important. So I'm happy when the client comes to us before he started the project and before I find mistakes on the website and everything. So implementation of the web shop, GDPR topics, data protection regulations, advertising issues. You often see reviews of consumers which are not reviews of consumers. So they're
Okay.
just fake pictures and fake reviews. Those are the issues I try to stop beforehand. So that's kind of a legal boot camp. And when there are new regulations, of course, I inform the clients and tell them if there is the need to adapt something. So that's part of our job. If there are any news, to inform the clients on a regular basis if they have to change something or not.
Okay. So now let's maybe pick out one piece, right? I know you have so deep knowledge in all those little sectors, right? But you mentioned that in the law, even the checkout process of a shop is determined. What are the specifics that the law really requires in such a checkout process? Because I would assume everybody is downloading, I don't know, a shop software, right? Is putting their pictures on it, putting the products on it, put Stripe or any like ADN or whatever payment service provider in place, right? Make sure that receipts are being printed, at least in PDF, right?
Yeah.
And then off they go, right?
That's kind of how it works.
Right?
I mean, from a legal perspective, it's important that in the end, at the checkout process, you find like the product you go for and all the important details. Like, for example, if I buy a dress, the color, the size, how you wash it, and everything. So all the important information, which of course depends on the specific product, and then that there are not like many steps in between. So you see the product and you do the checkout process. And what is often done wrong is the wording at the button. In German, it's called zahlungspflichtig bestellen. So that the consumer is aware that when he clicks that button, he has to pay something. And there are often buttons where it just says, go further or order or something. And the problem is the wording. If you're not aware that it costs money, it's a wrong wording for the button. So those are the mistakes that I often see at work or when I shop on my own. So this should be done right. And of course, the information about the right of withdrawal. You said when you download a software, there are certain regulations for digital products because you have normally 14 days for your right of withdrawal without any reasons. But if you download something, normally you want to use it now and not in 15 days. So there always has to be a checkbox where it says that you refuse the right of withdrawal so they can provide you with the product now. And those are the issues that are not always done right in the checkout process.
Okay. Very interesting. I will make sure to check if everyone has those buttons. In the Directive of Unfair Commercial Practices, I had to read that. It's a complicated thing. So, Directive of Unfair Commercial Practices. This is basically one of my competitors as a business makes a marketing stunt that is not legal. I discover it, and then I can sue them.
Yes.
Is that right?
Yes.
Okay.
That's the basic of the Federal
Okay.
Act Against Unfair Competition. Yeah.
And what do I need to show, right, to have a case? Like, let's say it's two online shops, both sell hoodies, right, from the same brand, and I know now that hoodies in this example, they are regulated in terms of price, right, and one shop claims it's 40% discount, but it's actually the same price as my not discounted regulated standard price that I have on my website. So I think that the other shop is basically faking the discount and making it cheaper to buy with him while he doesn't. Can I sue him, or do I need more information?
Actually, when a client comes to me with that, I need more proof. Like, that's something I think you observe 1 or 2 weeks, because that's not enough for
Okay, screenshots.
screenshots, proof, and maybe if the pricing, as you said, it's 40% discount, but you saw like the hoodie was worth, I don't know, 50 2 weeks ago, and now it's 80 but 40% discount, so it's obvious that the discount is not a real discount. But in these cases, all things like they need to be observed, screenshots and proof and everything, otherwise it's really hard to file a lawsuit
Okay.
and win it without proof.
Or settle out of court, right?
Of course, yeah.
Just to make a case.
Yeah.
Now, let's say I have a case, right? But my opponent, right, a shop where I think they make millions, in reality, they just make a couple €1,000, right? Because they really don't sell, right? Can I still sue them on a respectable, interesting amount? Or does this depend on the size of my competitor?
It doesn't really depend on the size, but I think if you try to reach an out-of-court settlement, it makes sense that it's a reasonable amount of money. So otherwise they will say, I won't go with it, and then you can file a lawsuit. But I think it should be reasonable for both of you. So of course you can file a lawsuit. That's something you can always do. But I think it makes sense if you know they don't sell that much of the products to find a reasonable amount you want to have.
How many European startups do you know that, or businesses do you know that sue each other on these topics? Is this a very common practice, or is it rather seldom?
I think it's not really common, like that it's going to court. I think most of the things happen beforehand with out-of-court settlements and everything. And I think it's usual you see someone else doing it. I mean, it depends on your business idea that you're trying to find someone who is doing it worse, or do you more focus on your business? But I think if you have the time and maybe the money and the resources, it makes sometimes sense to find the mistakes of others. But I think it's not the main purpose that should be in your business. So
I would assume it's not a business case. I mean, unless you are a lawyer.
Yeah.
But okay, so, and in social media and influencer marketing, I mean, I think it's the dream of all the young kids out there, right? Becoming YouTubers and being influencers, being paid for posts on Instagram. How regulated is that?
Well, most of the regulations are in the Federal Act Against Unfair Competition, and there is a wording in the Media Act where it says that if you are posting an advertising content, it should be declared as advertisement or paid sponsorship, paid partnership, and so on. So we have in the Media Act a special wording you can use and you should use from a legal perspective. So if you are posting advertising content, I always advise you to use the wording so that the consumers, they're not like thinking, is it advertising, is it not? So the more specific your wording is, the more clear is it to the consumers, and the better is it for you from a legal perspective.
Okay, and if I truly like a product, I don't know, my Coca-Cola, right? Can I make marketing and not make money and not get money for it?
It depends, because for the legal aspects, if you have to declare it as advertising or not, it doesn't depend on the fact if you got money for it or not. So the influencers who, I don't know, have 500,000 followers and they advertise a product, they still can be reliable for that if it's, let me say, overwhelming advertising, like not just I'm drinking Coke and that's it. So you can see here the bottle, and it depends on how you present the product. And if you're an influencer and you receive the product and you didn't get paid for the advertising, you still have to declare it as advertising. If you present it in a, let me say, non-objective way.
Okay, so if you're a car enthusiast, you just bought a Porsche, you're proud about it, and you present it to your friends on YouTube, you might run into trouble if you have too many people following you.
Yeah.
Jeez.
Yeah.
Okay, so a lot of content is not going to be published. Yeah. Okay. Now, what's also interesting is direct marketing, right? From a legal standpoint, right? And I'm not talking daily practice. From a legal standpoint, we cannot call someone that we have identified where we saw on the website that there's a phone number if we don't know them. We cannot write them emails, right, if we don't really know them, right, unless we got a business card. The common perception is just connecting with somebody on LinkedIn, and then you can write, this is a workaround. You might say, no, this doesn't work either. What is legally actually possible? And is this, I mean, it's massively different into how business is done in reality. How do you see that?
Like from a legal perspective, the only chance that you can send emails regarding marketing is by receiving an explicit consent. And by receiving an explicit consent, I mean actively ticking a checkbox and not removing the check from the box. So legally, there's only one chance if you concluded a contract with someone and you receive the contact details. For example, if I buy something in an online shop and I click the checkbox that I consent to receive the newsletter, and they send me a newsletter 2 weeks later about another shoe. Like that's something that is fine, but that's the only real legal exemption. So the cases you said, like cold calling is prohibited, of course. Sending emails to someone because you found the email address on the internet is not possible from a legal perspective. And also the LinkedIn messages. I mean, I see from a legal perspective, it's really hard to contact someone you don't know just to inform them about your products. And I see the LinkedIn messages myself every day. But from a legal perspective, you're not allowed, strictly speaking, you're not allowed to send LinkedIn messages. And only because you connected with the person is not the explicit consent that is required by law.
Right. And if that law would make sense, a lot of people would actually sue for those people spamming you, calling you, right? In my case, they always have terrible timing. And this really doesn't happen. Why is that?
I mean, if someone is calling you as a private person, your only chance to take that somewhere is to report this person by the authorities. And the authorities, they are the ones who impose the fine. So if someone's calling me and I think about, well, that's direct marketing, he's not allowed. I personally don't have an advantage, or I don't get money out of that. I just have to report this person. And I mean, that's more work than doing something else. So yeah, only the authority is the one imposing the fines, but I don't have something out of that. So that might be a little bit weird.
So the government is effectively asking us for support to collect money, right? Because cold calling fines went up to what, 100,000 euros?
Cold calling 100,000 and sending email letters up to 50,000 euros.
Wow.
So, I mean, that's not a sum that is like imposed the first time normally.
Okay.
But if you're someone like a company and you do that every week or every 2 weeks and the authority sees that, I mean, they will impose a higher fine than if that happened just for the first time and you say you're sorry and it will never happen again. Hopefully it really never happens again. But yeah, the amount is really high.
Yeah, so you have to be repeatedly terroristic.
Yeah, kind of, yeah.
Okay,
Yeah.
Okay, get that. Okay, and maybe the last topic to touch, everybody talks about the big elephant in the room, artificial intelligence. Now, the European Union has this great idea of an Artificial Intelligence Act, which will make the strict data privacy regulations, the GDPR, even stricter, are kind of interlinked. And there's Digital Services Act, which is also kind of interlinked to the whole thing.
Yeah.
Why is the European Union trying to regulate this sector, and what are they actually trying to regulate? What's the problem for the government?
I think that they are trying to put that in a legal, secure way, because no one really knows like what's coming and what are the consequences of using AI. And I think a big part of it is consumer protection, especially in the Digital Services Act, that people, they don't know if AI is used. Am I writing to a chatbot or to a real person? And I think a lot of it is for the security of like natural people. If they are not aware of that, they get the information that AI is used or that AI may be in the background. And I think that's a real issue why the European Union is doing all this. But I think from the data protection point of view, it's not really getting any easier for companies, startups, whatever, to implement everything, because you have more regulations, more laws to keep in mind. So from a business perspective, it might not be so helpful, but from a consumer law perspective, it might make sense.
Okay, but I mean, you know, innovation always needs brave people.
Of course.
Right? There can be a lot of good things done with innovation, and also, I mean, innovation always can also be harmful in some aspects. But obviously, in the startup ecosystem, more regulation, right, is hindering in terms of competition, global competition, where other regions have less regulations in this sector. Interesting. So there's a lot of European perspective that goes into the national laws in the European Union. I can see that startups have a great attorney on their side connecting you at STADLER VÖLKEL. And I hope you enjoyed the show and learned something for yourself. Make sure to subscribe to our channel and tune in for the next episode. Thank you and goodbye.